Good afternoon, everyone. This is John Rust on Rust on the Radio, the John Rust Show on Freedom 95, broadcasting at 9:50 a.m. and 95.9 FM on your radio dial, the right station for talk, right here in the beautiful and now snowy state of Indiana. I'm here in the studio with Justin. Welcome to the show, Justin.
Howdy, John. Always happy to be here.
Did you dig out from all the snow?
Oh my gosh, that was terrible.
So, folks, today we have a special guest. His name is Ken W. Good, and he's calling from Texas. So, Ken, how were you with the snow? Did you all get hit down there?
We did. We got hit. First of all, thank you for having me. But yes, we got hit pretty good, but mostly with ice. Texas doesn't deal well with ice. This is the third day in a row our schools have been shut down. Our courts are opening late today. Some of them in like Dallas is closed for today. But we're recovering pretty quickly.
Fantastic. Same in Indiana. People are starting to dig out right now. So you drive down the road, and for me, it looks like the winter of 1978. But I remember the blizzard years back then, and it's a very similar situation with all the snow on the sides of the road. It's a lot of digging out for all of us. And we didn't have any ice, so our power stayed on, fortunately. So we were very blessed on that.
Our power was on the whole time. Our driveway goes down, so to leave our house, it's like going up a hill. And when I was getting out yesterday around midday, I didn't know if I would make it up the driveway, but I did. So
yeah, same with me. I made it though. Fortunately, I have four-wheel drive, so it was okay. But got to get out to feed the chickens. So, folks, Ken W. Good is a professional bondsman from Texas. He graduated from Hardin-Simmons University in 1982 with a Bachelor of Arts degree. He received a Master of Education degree in 1986 from Tarleton State University, and that is part of the Texas A&M system. In 1989, he received his law degree from Texas Tech School of Law, where he was a member of the Texas Tech Law Review. Mr. Good has argued cases before the Supreme Court of Texas and the Texas Court of Criminal Appeals, along with numerous courts of appeals, including the United States Court of Appeals for the Fifth Circuit. He is the author of Goods on Bail, a practice guide created for bail industry professionals. In addition, he has written numerous articles on the subject of bail reform, including what successful bail reform looks like. Mr. Good is married and has two daughters. His website is www.pbtx.com. Mr. Good, welcome to the program, and thank you so much for this fascinating topic to discuss today about bail reform.
Well, thank you so much for having me. I mean, listening to you talk about my history just reminds me that my parents accused me many times of being a professional student, and I kept telling them that, no, I couldn't be a professional student because a professional student never graduated, and I kept graduating. So
well, there you go.
I kept saying, by definition, I'm not a professional student. I just keep going along and along, and so... and also, it just makes me think how old I am. I'm fixing to turn 65, so thanks for reminding me.
So do you remember did the blizzard hit Texas back in 78 so much?
I mean, we had one probably in the last 5 years where, we couldn't leave our house and didn't have electricity for days, and then we couldn't leave our house for a week. So that's the one that keeps sticking in my mind. But I do remember when we had like a little kid. Our oldest daughter was very little. We hung out on front of the fireplace for a couple of days. It's very rare. I mean,
this storm up here, we had 18 inches of snow near Seymour, Indiana, where I'm from. And fortunately, it did not drift shut, but it reminded me of when I was 11 years old back in the winters of 77, 78. We had two bad winters in a row, and I was 11 years old, and my family threw me in the chicken houses with a butane torch, and I had to go up and down the aisleways heating up the water lines for our chickens so that their water line would not freeze because it was so cold.
Well, I'm just telling you, with 18 inches of snow, I mean, my response is I don't even have clothes to wear for that kind of weather because, I remember many, many, many years where I'm putting out Christmas lights wearing shorts. I wouldn't know what to do with 6 inches of snow, let alone 18 inches of
We're
snow.
dressed appropriately. Justin's in the studio, and he has a big sock hat on. So it's like we're in the blizzard right here.
I've been to Erie, Pennsylvania during lake effect snow and, for Thanksgiving one year. I stayed by the fireplace the whole time. I was like, I don't have any clothes to go outside.
That's a good place to be today. So, folks, the reason for this show, and we talked about this briefly in a previous show, is the horrific murder of Iyrna Zarutska, a 23-year-old Ukraine refugee who was fatally stabbed on a Charlotte, North Carolina commuter train on August 22nd, 2025. The attack occurred at the East-West Boulevard station where she was stabbed from behind 3 times. And so, Ken, do you remember all the pictures? She's sitting there minding her own business, looking at her phone, and she's attacked from behind. And the suspect is named DeCarlos Brown Jr., who was arrested and charged with first-degree murder.
I do remember it, and the video is horrific, and the story is terrible. I mean, here's a family from Ukraine where they, came to the United States. They came the right way, everybody but the dad, because men during of certain age are not permitted to leave Ukraine because of the war. But the rest of her family left and came to the United States. They had sponsors, so they came the legal way. And she was a student. She was working at a pizza place. She just got off work, and she was going home. I mean,
she was exactly what you said. She was doing the right thing. She was working at a job, and that means she was paying taxes. That's what it's all about. And she was attacked from behind.
She was just trying to get from point A to point B, and we would say, okay, well, maybe at 9 o'clock at night that's not the safest thing, but her mindset is there is nothing that would have not been more safe than where she came from, and it's public transportation. She's just going home. You would think how many thousands or 100,000s of people do that every day, and the person behind them decides to stab them for no other reason than they have a mental issue and because of the color of her skin.
Well, and it would be the same here in Indianapolis, for instance. Charlotte and Indianapolis, if you get on a bus in Indianapolis, you don't expect to be stabbed. Unfortunately, with what bail reform has done in the United States, now you have to keep situational awareness wherever you are at. And that's just something people today aren't thinking about. But, with what happened to her, it's something we have to do. And that's why we're having this discussion.
Well, these soft on crime policies, and where we're really seeing them is in our inner cities, which Charlotte was, and what you're talking about is as well. And, we get these soft on crime DAs, and they think they know better, but the problem is they don't even look at the science because they're flooding the Google with pseudoscience that is contradicting what the real science says, and they'll never admit they're wrong. You can show them and say, well, this didn't work. They don't care. Activists will never admit they're wrong.
And that's the same thing that's happening here in Indianapolis with our prosecutor for Marion County, Prosecutor Mears.
Yeah, he's terrible.
Well,
I just seen he's actually running for re-election. He just filed today to run for re-election. I just think that's terrible for the county because he is awful.
Well, the good news is these soft on crime DAs have a short shelf life. They don't last more than 2 terms, usually. 2 terms is usually 8 years. That's a long time.
You know what bothers me about that whole thing is it's an agenda. It's an agenda to turn criminals free.
And it's worse than that because they go, there's groups that recruit these soft on crime DAs. Once they give them money. Once they get elected, they send them to seminars where they're like, it's quid pro quo. Here's what we want from you because we got you elected. Here's the policies. And then here's the press releases that will sell it to the public. And it just is so organized. And like you said, it just does so much harm, and they're not ever going to admit that it's doing harm.
The suspect who was arrested and charged with first-degree murder for Iyrna Zarutska's murder, his name is DeCarlos Brown Jr. He has been arrested multiple times. Ken, do you want to go into that a little bit?
The biggest problem is we've got people attacking the magistrate because the magistrate gave him a personal bond or, release with no bond or, just on his little promise that he would appear. But, he was charged with harassing 911, and that's a misdemeanor. It's a low-level crime, but he has a substantial, long criminal history, and he served time in jail. So the problem with him is he already touched the criminal justice system so many times, and the criminal justice system failed him, and in failing him, failed public safety and failed this Ukrainian woman.
Some history on this, folks. Mayor Rudolph Giuliani, when he was mayor of New York City, one of his stalwart campaign issues was he went after low-level crime hard. He went after fare jumpers, just any minor offense, and he would prosecute people for that. As a result, crime dropped massively in New York City while Rudolph Giuliani was mayor.
Well, that's a proven theory of law enforcement. We teach it in our colleges, and it's called the broken windows theory.
Correct.
And the reason why he was attacked and why that was attacked, or that practice was attacked in New York, is because it was successful.
Well, he single-handedly, by doing that, made it safe to ride the subway system in New York City. My family, we've sold lots of eggs in New York City, and I've traveled quite a bit in New York City. I always felt safe back then on the subway. Today, I think it'd be a different situation.
Well, and how do we have public transportation if we cannot provide public safety to the people riding it? I mean, that's always been kind of the ultimate irony to me. I mean, is the job in public safety to provide opportunities for people to take advantage of citizens? No, it's to help them to get from point A to point B.
To go to work, to go to their job, to pay taxes, to provide for their families.
The condition of that is to provide a safe environment to do that. Why does that not even make sense?
And so what happened, folks, in North Carolina, what is now called Iyrna's Law, and it came into effect on Monday, December 1st, 2025.
But, Iyrna's Law is something that happened so quickly after this. I think the legislature recognized very quickly that they were using a simple release mechanism. And so I think one of the things that this Iyrna's Law did was get rid of that. They need to go further, and they need to get rid of some other simple release mechanisms that they use in North Carolina. The reason why the president issued an executive order encouraging or trying to facilitate the end of cashless bail.
Okay, so for the listeners, could you go into detail a little bit on exactly how this perpetrator was released so many times so easily and easily was able to be released onto the street?
I think the biggest reason why is because he had mental issues. And, we have a long history, and I would say a bad history, on how we treat mental health patients in the United States. We used to have a series, or we had a bunch of mental health facilities. Those institutions don't have a natural constituency. So anytime a county or a state wanted to save money, their budget got cut first. And as a result, there's some really bad atrocities through history dealing with mental health facilities. And there was a series of class action lawsuits that predate probably when I was born, which facilitated a lot of the closures. And as a result, a lot of the mental health patients were kind of moved into the criminal justice system. Initially, the jails and the prisons became the largest mental health facilities in the states. But then with criminal justice reform, we don't want to do that anymore. And so but we don't have an alternative. So we're making a mental health issue the King's X on the criminal case, and they just release them. And so it's becoming this cycle until they commit a really bad crime, and then they'll keep them. And I think that's really what happened with him. He would be arrested, released, arrested, then he would get a bad crime, he would be kept, and he would serve time in jail for that. Then he'd get released, and then he would have more arrests, but they weren't severe enough, so they would just X the crime and send him back out into the public, and that's what's happened. I think that's happening many, many times over, and I keep saying if we could find a solution to the mental health crisis in our country, we could be billionaires, because there's not a simple solution, and any solution to that is very, very, very expensive, which is the reason why they lost their support initially.
Well, I always like the 3 strikes and you're outlaws. What's your opinion on those?
You know what? I like those. I like those a lot. I'm fine with us giving mercy to someone who shows that they've reformed, but the federal government has no ability to do an individual determination on who has changed and who has not. That's the reason why they do across-the-board type releases when they decide to show mercy, and those usually are not a good idea. I like the 3 strikes, but what if we had 5 strikes? I mean, we've got situations or examples.
Because this guy had 14 strikes, as I understand it.
Well, yeah. In Houston, we've had examples of 17 strikes and you're not out. So let's have some strikes and you're out. So, yeah, I like the 3 strikes and you're out.
So, folks, we're out of time for this segment, but when we come back, I'm going to ask Ken, why does it matter how we release somebody from jail? This is John Rust on Rust on the Radio. We will be right back. Welcome back, folks. This is John Rust on Rust on the Radio, the John Rust Show on Freedom 95, broadcasting at 950 AM and 95.9 FM on your radio dial all across the beautiful, snowy plain of Indiana right now. So I'm here in the studio with Justin. Welcome back, Justin.
Thank you for having me.
And Ken W. Good, a noted bail attorney from the state of Texas. So welcome back to the show, Ken.
Thank you very much for having me.
So before the break, I was asking you, why does it matter how we release somebody from jail?
That's a really good question. What the public doesn't understand is, when we are releasing somebody from jail before their charges are resolved, that doesn't have anything to do with guilt or innocence. It always kind of gets on my nerves when somebody says, well, there's a presumption of innocence. Absolutely, that we do, but that applies at trial. When you get arrested and you're waiting to have your charges resolved, it's all about what assurance you're going to give the court that you're going to return to respond to the charges. And if you can't give the court some type of assurance, or if you keep showing that you will not abide by your assurance, the court has the ability to keep you and hold you until your underlying charges are resolved. So the type of release matters, and it matters from the standpoint of we already have backlogs in our criminal courts. They're already so busy, and so there's already all these pressures on them. Well, the type of release has different failure to appear rates. So the private industry has a failure to appear rate of less than 10%. But these simple release mechanisms like, the president has identified in his cashless bail, those carry very high failure to appear rates. So in California, we call it release on zero bond. In New York, we call it release on no bail. Texas, we would call it being released on a personal bond. All of those are simple release mechanisms where the only assurance you're giving the court is your promise. And those have high failure to appear rates. And like 50 to 80%. And, when you, in the criminal world, if you don't show up for court, they can't go forward with your case. It has to be put on hold, and it waits for you. And so you can imagine what impact the different types of release mechanisms have on the criminal courts. If you have one type that's less than 10%, and you have others that have a 50% failure to appear rate or an 80% failure to appear rate, and you're still arresting the same number of cases on average every week, the type of release matters, and it matters because it creates huge backlogs in the courts. And backlogs put pressure on courts to dismiss cases, and dismissing cases, criminals view that as a green light to commit more crime. So and that's what we're seeing in our urban cities.
Okay, so these types of releases, can you go over specifically some of the types of release that we have today in Indiana, if you know that, and in Texas?
Okay, so I can give you a bunch of different examples. Like in Texas, we have three types of releases. We have release on a surety bond, which would be the private industry bail bond. It's like an insurance product. You go to a bondsman, you pay them a premium, and they post your bond, and then you get released from jail. If you break your promise and don't show up for court, then your bond is forfeited, and then there's a whole set of rules that apply. And if you don't ever return in Texas, then the bondsman's going to have to pay the full face amount of the bond to the court. The second type that Texas recognizes is a cash bond. So instead of paying a premium, so like for a $10,000 bond, you might pay a bondsman $1,000. Well, instead, on a cash bond, you would post the whole $10,000 with the court. And then the last type of bond that we have in Texas is a personal bond, which is just your personal promise that you will appear. It gets real confusing because a personal bond might still have a $10,000 monetary amount tied to it, but it's just your personal promise. Nobody's guaranteeing it. And then when we get to other states, they might have a 10% where you can pay to the court and call it a 10% bond. I think Indiana does that. It still has a high failure to appear rate, and also it becomes problematic because then the courts become reliant upon that 10%. So you're relying upon people's failures for you to be operating, and so that's kind of a bad situation. And then we have like charitable bail funds in some places will post the cash bond for the defendant. So those have high failure to appear rates as well. I'm trying to think of Illinois, which is close to Indiana. They got rid of the private surety bail industry probably 10 or 20 years ago, but they've been all over the news for the last year saying they got rid of cash bail with the Safety Act. But all they got rid of was the 10% bonds to the court or posting a full cash bond because they'd already gotten rid of surety bonds. So they just made a bad situation really, really worse because their failure to appears were already bad. And there's been some statistics out of the Clark County Clerk's Office saying that the failure to appear rates under the new system are at least 70%. And so those are all recipes for disaster. I mean, the only thing that can prevent your criminal justice system from collapsing in that situation when you have high failure to appear rates is to just dismiss cases. And we've already talked about what happens when you do that. Criminals see that as a green light to commit more crime.
Exactly. And that's what happened in California. They used to have a very good law. It was called the 3 strikes and you're outlaw, where on your third conviction, you were put in prison for life, basically. Is that correct?
Yes, and that's what happens in a lot of places. But, I think when the new DA in L.A. was elected, not the current one, because I think Gascon had 2 terms. He was a soft-on-crime guy. He told his assistants to quit, seeking the 3 strikes, and I think
is that law still on the books?
That. Yes, but the soft-on-crime DAs, I believe, they control whether they seek it. The problem in California is so bad. It's from so many different directions. The first thing they did was they passed Proposition 47, where they changed certain felonies to misdemeanors, including theft under $950. Well, then our urban cities decided, their soft-on-crime DAs decided they weren't going to prosecute that anymore. So you can imagine what happened then. Theft of $950 just took off, and then commercial property values just went through the basement. And so they repealed that in the last election, but the repeal hasn't been funded by the legislature. So there's all kinds of games going on. And then they have the worst thing in California is there was a court case putting limits on how many people could be held in their prison, and they've refused to build additional capacity. So they've got that backdoor pressure to decriminalize crime so they can keep their prison numbers under a certain arbitrary amount. And it's not about prison conditions. It's about inability to provide certain medical care. But the order for release isn't for people who have medical conditions. It's just across the board. And, when the issue went to the U.S. Supreme Court, the minority that lost, or the dissenters that lost, said, when you release the equivalent of a brigade of criminals back into the public, you have to expect there will be more crime. And, of course, that's what's happened.
And it's giving more crime. And what it's specifically doing in California, folks, and all across the country, is it means if you walk into a CVS or a Walgreens, you're going to see everything locked up behind glass cases. If you want some toothpaste, you're going to have to ask for a key to get in to get toothpaste out.
Well, you may even have to pay for it first before they'll give it to you. And you're seeing that. The ramifications of that are all across the country. And then in California, with what they're doing on minimum wage, you've got fewer employees that you can even find to get the key to unlock to get you something.
So here's a question I have for you. There are these groups that go around and steal from Home Depots and Lowe's, where they go in and just walk out the door with chainsaws and power tools, and they are never prosecuted. And the employees at the stores are told by management, do not interfere with that, because it's a safety issue for them. But what that's doing for us folks is that means you're paying a higher and higher price for your chainsaws and for your saws and for your drills.
But what people don't realize is how this comes about. So you've got soft-on-crime policies where we're not going to prosecute certain low-level offenses. Okay, you could probably say maybe, okay, I can understand that. We're setting priorities. But the problem is when you've got gangs, career criminals, organized crime, then they look at what the soft-on-crime politicians are doing, and they're like, okay, so they're not going to prosecute people for that. So let's concentrate on just doing that. And those groups figure out how to make millions of dollars taking advantage of these soft on crime policies. And that's what's happened.
And that, folks, that's happening right in my own county, in Jackson County, in southern Indiana, a ruby red state, a ruby red county. What's happening is, and it happens in our own big box store, the local Home Depot, where these groups walk in, load up their carts, and go out. And so now what's happening, they are locking everything up. So you cannot get a chainsaw anymore or a drill. You can't just walk to the cash register and pay for it legally, because the criminals have made it so that the stores have to do that to protect their inventory in Jackson County, Indiana.
I mean, this is what that makes me think of is, there's a lot of studies that say most crime is being done by a small group of people. So, like in your city, you've got a little bitty sub-minority that's probably committing 60% of the crime, and it's the crime city within the city. The problem is you've got this little gray area between the law and order citizens and the crime city, and they're watching every day to see, are the crime citizens being held accountable for their actions, or are they not? And when we have soft on crime DAs, crime's increasing because the people living in the gray area between the two law and order and the criminal elements, they're making their decision on the soft on crime policies. And so when we have law and order, those same people are making the decision, we don't want the consequences of committing the crime because we're seeing what consequences are being done on the criminal element. And also, when we have law and order and it's a small group committing 60% of the crime, those people are being addressed. They're not being released 14 times. It's not a revolving door at the jail. And so, obviously, we're safer because that small group is being handled.
Back on Iyrna's law. Okay, so that passed, and it is in effect right now. Can you go into the details of what that law did to tighten up anything, if it did, in North Carolina?
I think it was trying to address the situation with Mr. Brown, and Mr. Brown was released on a specific type of simple release mechanism in North Carolina, so they got rid of that. But he also had mental issues, and so North Carolina was like other states where it's very difficult to refer somebody for mental health evaluation. Like in Texas, you can refer somebody for a 72-hour evaluation, but they have to be either at risk of harming themselves or someone else. If they just have a mental health issue, even if it's substantial, under that test, you can't refer them, to a facility for 72 hours. And so I think they made it easier for that to happen. They also required the review of criminal histories in setting bail. I always think in reviewing criminal histories, that's a common sense thing. In 2025, when this law went into effect, you would be thinking, why aren't we already doing that? And, really it's a technology issue. Like in Texas, we've only started requiring criminal histories to be reviewed in the last 4 or 5 years, and it's because we didn't have a database that was easily accessible for the judges to review a defendant's criminal history. So I think technology is helping with that. And so I think that we have the mental health. They got rid of one type of simple release. They need to get rid of others. And then they required the review of criminal histories. Now, there were other things addressed, like in North Carolina, there was only one court of appeals in review capital murder convictions. And so another part, probably the most controversial or talked about part of Iyrna's law, was they distributed those appeals to the rest of the state. So if you have an appeal of a capital murder conviction, you can take it to your local court of appeals instead of to the Supreme Court or the highest court in North Carolina directly. And I think that was probably the biggest problem. I think on the national news, Iyrna's law was portrayed as getting rid of cashless bail. It got rid of one type of cashless bail in North Carolina. There are others that remain, but I think there'll be attempts to end those as we go forward. I think it was a good start, but there's more work to be done.
So, folks, we're out of time for this segment, but when we come back, this 34-year-old suspect, DeCarlos DeJuan Brown Jr., what's the situation going on right now with him? So when we come back, we're going to dig right back into this. This is John Rust on the Radio. Welcome back, folks. This is John Rust on Rust on the Radio, the John Rust Show, broadcasting on Freedom 95.9 FM and 950 AM on your radio dial, the right station for talk all across our beautiful, snowy Indiana. So here in the studio with Justin, and we are interviewing folks, Ken W. Good in Texas, and we are talking specifically about the murder of Iyrna Zarutska. I want to dig into this about this DeCarlos DeJuan Brown Jr. He has been arrested 14 times in Mecklenburg County in North Carolina, before the stabbing, with criminal charges dating back to 2007. On April 11, 2014, he was convicted of breaking and entering. While on probation, he was arrested for armed robbery and possession of a firearm by a felon. Brown was convicted of armed robbery and incarcerated in a state prison from 2015 to September of 2020. Upon release, he initially lived with his family, but his mother told ABC News that he was diagnosed with schizophrenia at that point and displayed violent behavior at home. His mother said she sought involuntary commitment but was denied. So, Ken, that exactly relates to how we're talking about how you get all these criminals who do all these crimes, but they are just continually released and released.
Well, also, his mom, took him to the halfway house because she couldn't control him, probably because he went off his medications, which is the recurring problem with mental health issues, where someone gets arrested, they're off their meds, they get into jail, they get back on their meds, and they get controllable, they get released, and then they get off their meds again. And it's just a vicious cycle of going through the door and out the door, in the door and out the door of the jail. And this is a really sad situation because even his mother said he should have been in jail. It's really sad when your own mother is saying should have been in jail.
Right, and the courts ignored that.
Yes, and again, I think it's because of the push on these soft on crime policies to not address mental health issues. It's just the King's X. The problem is, since we've made our jails and our prisons the largest mental health facilities in the state, if you just use a King's X and say we're not going to do that anymore, there's nowhere else for them to go. I mean, we don't have the infrastructure and a private system to send these people. When the courts do, there's such a backlog, such a waiting period, that it's just a farce. And that's why you see this people with these substantial criminal histories where they have to commit a substantial crime before the criminal justice will hold them and not just turn them loose anymore. And we've got to figure out a better solution to that. Like I've said before, that is a very complex issue and costly. There's no solution that's cheaper than what we're currently doing, keeping them in jail.
What is the present situation on DeCarlos Brown?
Well, there's two cases pending. So there's a state case, and state case is murder, but it's difficult in North Carolina to get, the death penalty based upon his situation.
And
so
I believe
also,
I believe the death penalty has not been used in North Carolina since 2006.
So in addition to that, the federal government has come in and filed federal charges causing death on a public transportation, which does give them the option to seek the death penalty. But even there, it would just take a change in administration to a soft on crime administration, and they would just commute his conviction to life instead of death.
What do you think a timeline will be for justice to be served on him?
I would say 3 years to get the trial done, maybe less. But then after that, a decade on appeals. When you have a high-profile case, sometimes they move quicker through the system. But these cases, when they go up on appeal, take forever. And there's all kinds of ways that you can slow down a case. Just because you go through the appellate system doesn't mean the appeal is over, because then you can file a writ of habeas corpus in federal court, even if you're on the state case, and it's kind of like you start all over again with a new appeal. That's the reason why it takes so long.
What are the possible punishments he could face first under the state and also under the federal?
I think with the state, the most likely punishment, if he's found guilty, would be life in prison. If he's not found not guilty by reason of insanity or something, on the federal system, I think the death penalty will be asked for. Well, yeah, I think this is a high-profile enough case where death penalty will be on the table for the federal charge, and the question is whether the jury will give out that sentence. I mean, I can see the federal government letting the state go first, especially if the state seeks the death penalty. But I think the most likely result is the state does not seek the death penalty, and the federal government comes in and pursues its case, and whoever is seeking the death penalty probably will go first.
If he is convicted and gets life in prison, will that be life in prison, or will he be eligible for parole at some point?
That's going to be determined by North Carolina law, and I don't know the answer to that question. I don't know whether in North Carolina life means life, or like in Texas, life only means 20 or 30 years. Isn't it weird how sentences in statutes don't mean what they say anymore? And a lot of times they say, well, it's because we have jail overcrowding. Well, I'm like, why don't we just lower it, change the statute to say what we mean, instead of saying, well, you're going to get 40 years, but because of all these regulations and good conduct time, it's only a quarter of that.
Well, and I think the politicians have got involved there, where it still sounds good that the prosecuting attorneys are getting, I got him life in prison, even though it may only mean 10 years.
I do think that's true. I think that's a true statement. I mean, we always have politics. In this era of soft on crime, criminal justice reform, bail reform, politics has really gotten more involved in criminal justice than ever before, and we've got to find a way to get politics as much as we can out of criminal justice. Historically, both national parties have been law and order parties, and it's only when one party, and it's usually the same party, becomes soft on crime that we have these cycles where we become more forgiving on our criminal laws, crime starts going up, then we have a disagreement on how to handle it. We have one end of the spectrum that refuses to participate. When that happened in the 60s, one of the results was Ronald Reagan was elected and his war on drugs. And I think we just have had the same thing happen now, and that's one of the reasons why Trump was elected, along with the immigration policies of the previous administration.
So what's happening in California versus Texas on what you think is on this type of bail reform in terms of actually getting back to making criminals pay for their crime?
Okay, so let's talk about what California is doing from the misdemeanor perspective. So they use simple release for all misdemeanors across the state. I did a podcast with a DA from California. He said they have a 80% failure to appear rate across all of California on misdemeanors. If a misdemeanor defendant goes from one county to the next, you cannot force extradition. They won't go and get you because they just won't. It's a misdemeanor. But then on top of that, they have a Speedy Trial Act requirement. So if they get arrested, they get released, they refuse to come, not only are they not coming to get you, they have time limits on when they have to do certain things on their case, and if they don't do it, the case is dismissed. Misdemeanors in California become voluntary on whether you're going to get your case resolved in many situations.
Now, how long will those convictions or legal actions stay on the books? Say, for instance, someone walks into a drugstore and steals $800 worth of product and walks out and gets charged with that, but then never shows up for court. What happens if they, in another part of California, get arrested for speeding? Will that get flagged? It'll
get flagged, but since it's a misdemeanor, they won't do anything about it.
So it's meaningless. So all you will have to deal with is their speeding ticket, and the officer will say, "Thank you, have a nice day," and you go on your way.
Yeah, here's your ticket, and that's a problem, and that's a really bad problem. We haven't gotten to that point in Texas. In Texas, you still will be extradited between counties. They won't go outside of Texas to get you for a misdemeanor, but they'll go to another county. They may elect not to for certain offenses, but by and large, they still will come and get you. They'll, if you have a traffic stop and you have a warrant for your arrest from another county in Texas, they'll take you in. The other place may have 10 days to come and get you, and if they don't, they'll release you. But they're going to take you into their local jail, and they're going to notify the other county that they're holding you, and to see if you're going to want them to come get you or if you're going to post bond.
So, folks, we are out of time for this segment, but when we come back, I'm going to ask Ken, what does successful bail reform look like? This is John Rust on the Radio on Freedom 95. We will be right back. Welcome back, folks. This is John Rust on Rust on the Radio, the John Rust Show, broadcasting on Freedom 95, 950 AM and 95.9 FM on your radio dial. Broadcasting all across, and I keep chuckling about it, but it is very white out. It is very snowy out. It is a true winter. Where is global warming when you need it? So before the break, I was asking Ken, what does successful bail reform look like?
Well, I think, I've actually written an article about what does successful bail reform look like, and I think that it's the opposite of these soft on crime policies. There's a study that was done by a DA in California using his data during COVID, and he compared someone released on a simple release versus somebody released on a private surety bond, and they were both nonviolent offenders. And he found that the simple release person had a 200% greater chance of committing a new violent offense in the next 18 months. That tells you that soft on crime policies make the situation for a defendant potentially a whole lot worse. If we release them simply and then they commit a new violent offense, now they're looking at a much more, the misdemeanors become the training ground for tomorrow's felonies. We've got to stop doing that. And the way we do it is by having a strong accountability element of our criminal justice system. We've always had that. Suddenly, with this soft on crime policies, we've stopped. We have situations where people are released 17 times in Houston, Texas. They're released and they fail to appear 17 times, and they don't do anything to them.
Because there's no consequences.
Release them again.
Right.
Because there's no consequences whatsoever. And if you don't show up to court 17 times, that's not going to happen in my court. It might happen once, it might happen twice, but I promise you on the third time, I'm holding you until your criminal case is resolved. And I believe that you have the ability to do that. But the problem is on these soft on crime policies, they're taking the position that activists are saying, well, the judges can't hold them. It's just a misdemeanor. No, that's the backbone of our criminal justice system. We have to be able to resolve cases. If they can run and hide and prevent us from even resolving their criminal case, then our system does not work. And the reason why I'm so hopeful that this bad bail reform is failing across the country is because it's just not sustainable. I mean, our public demands public safety. And if we do not give public safety, we go back to like during the Old West. We have a posse, and the posse goes out and gives out justice. We're already seeing that in a few spots. We've had the guy try to help somebody in New York, and so what did they do on the subway? So they prosecute him for helping. And the reason why they prosecute him is because they're trying to keep other people from helping in these bad situations.
And that is what is so incomprehensible, is how the left thinks it is bad to be a good Samaritan and help someone in trouble.
When we've turned everything upside down. Day is night, night is day.
And that's why I really liked Rudy Giuliani as mayor of New York City back in the 1990s, because he absolutely cracked down hard on what was called minor crime, but it absolutely had an effect on big crime falling drastically in New York City.
We don't have a good view of what is right and what is wrong anymore. We equivocate everything. I mean, is that where we are, where there's no such thing as good and bad anymore? Or there's no consequences? Okay, you killed somebody, so you have to answer for that. No, I mean, you had a mental issue, or that's where we are. We need to go back to, there are certain things that, okay, so you admit you were wrong, but there's still consequences for it.
So do you want to go into what exactly a surety bond is?
A surety bond is when you go to a bail bondsman and you say, I've been arrested, or your family usually goes to them and says, my loved one's been arrested. Their bail has been set at $10,000, and so they'll check the court's records. They'll confirm that the bond has been set at $10,000. So they will pay a premium to the bondsman, and then they will post a $10,000 bond with the court. And then once they post the bond, the defendant will be released from jail. Once he is released, then he's going to report to the bondsman. So he'll report either once a week or more until his criminal case is resolved. If the bail bondsman sees issues, like if he's out on a drug charge and they see that he started doing drugs again, then they can report that to the court, and the court can issue a warrant for their arrest. So the bail industry provides supervision, and they also get the family involved. I think the secret sauce of the bail industry is family involvement, and I think we discount that too much when we say, oh, simple release is the same. Everybody wants to get their cases resolved. When science proves that's just wrong every time. When your father stands up for you when you've been arrested and says, hey, I know you screwed up, but I'm going to post your bond, you can still turn this around, you can still be productive. That has a big consequence on defendants. And so when we use these simple release mechanisms, we're giving up on families to allow them the chance to turn their loved one around themselves.
And I think you hit the nail right on the head there, and obviously you're the expert on this. So that is a key component of what successful bail reform would look like. What is happening across the United States on actually implementing that now? Is there a movement to actually do away with these cashless bails?
Yes. So the President, Trump, has issued an executive order to end cashless bail. What he's done is he's asked the Attorney General to identify grants that can be withheld for jurisdictions that use cashless bail. I think outside of that, you're seeing rollbacks, like New York initiated bail reform, I think in 2000, and they have now rolled it back 3 times, and it's a major issue in this current election. I think Alaska tried it and then rolled it back and said it didn't work. So you're seeing where initial attempts at criminal justice reform, bail reform, were done. I think in those areas they're rolling them back now. Even in New Jersey, which is one of the earliest ones, you keep hearing about crime is violent crime is up, and we need to change the bail law. What you're really seeing is all of these jurisdictions that initially tried it have rolled it back. You're seeing these soft on crime DAs losing or deciding not to run again. But then you still see the activists pushing other soft on crime DAs for new elections. But I think we now have a press that's they realize it, and so they kind of cover up.
Right, and it's like I gave the example of the local Home Depot. You don't hear anything about that in the press. It is completely glossed over, and it is not an issue. I only know about it because I know people that work there, and they talk about how they are forbidden to even try to stop the crime from taking place. And that's just where we're at. But I think the tables are turning with people like you working to bring common sense bail reform back to the United States.
Well, I appreciate that. What I tell the bail industry is if we're not telling the story, because I think our story is the truth, then no one else is. I mean, the activist groups aren't going to say, oh, our policies are not working, we need to find something else. Right. They'll never admit that. And, the Yolo County study, which President Trump cited in his executive order, was a study that I did a podcast about a year ago. So it's only through the bail industry getting out the correct data are we going to be able to fight these pseudo-studies and these activist groups. They have an agenda, and they're going to portray their agenda as fact, even when it's not true. And I've had debates with these people, and when you debate them and you point out the facts, they can't respond, so they just end up calling you racist.
But in the end, it is not racist to be against crime, because everyone is affected by crime, all races. Well, Ken, thank you so much for calling in on the show today. It has been a fascinating discussion. I hope to have you back again someday.
Well, thank you so much for having me.
So, folks, I'm going to close this program with my father's favorite Bible verse, Psalm 118, verse 24. This is the day the Lord has made. Let us rejoice and be glad in it. Ken, once again, thank you so much. Thank you, Justin. And I will see you all again next week on the radio.